We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, a psychologist, and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons unit, which is charged with investigating child molestation cases. The training that he has received is enormous. His resume is about 24 pages long. I think he's attended every major seminar ever given, and he's taught at most of these seminars. One of the things that I really like to point out is there is a gentleman named Dr. Stephen Ceci, who is one of the top suggestibility researchers in the world. Stephen Ceci does not like to testify. So what he does is he trains approximately 30 people a year by invitation only at Cornell. Harvey Shapiro was the only investigator that's ever been asked to come and train there. Since then, he's actually given training seminars at Cornell. In 1985, there was only about 1 line in the police training manual. It's called POST, Police Officers Standard of Training, having to do with false allegations. Several years ago, POST came out with a new training manual. Harvey Shapiro was the only defense investigator who was asked to be a consultant on this training manual. He's an expert in suggestibility research and one of the top investigators for the defense anywhere. Besides being a good investigator, he understands people. In representing you, he will use the same tactics that the police use. Let me give you an example. We had a client whose wife had divorced him, moved to Colorado, and every time he wanted visitation, he got accused of another act of molestation. She was living in this rich neighborhood with a very well-to-do doctor and felt that she could just throw lightning bolts down on her ex-husband every time he went for any visitation. One day, she woke up in her nice ritzy house in Denver and found that there was a gentleman named Harvey Shapiro going around door to door to all of her neighbors, finding out about the sex and drug habits of the doctor's new wife, which just happened to be part of the defense. The DA the next day got a phone call from the ex-wife telling the DA that they didn't want to go any further with the case, and the case ended up being dismissed. Harvey knows how to understand people and how to use that to our benefit. Another member of our team is Julie Schumer. Julie is a certified appellate law specialist. Again, the same thing as I said about criminal law specialists. She had to take a second bar examination after handling so many appeals, so many writs, recommendations from judges, and from her peers. Julie is highly unique. If you put Julie in front of a jury, I think she would pass out. She just does not want to be a public speaker in that sense. She's a Phi Beta Kappa English major from UCLA. She's a writer. She's a researcher. Normally, you would never meet someone like her unless you had lost your case and were up before the Supreme Court. However, we wanted to have our motions at the trial level to be of that top quality. They are so good that our motions are now copied throughout the state and are plagiarized all the time. Julie has a lot to do with the building of our motion banks. For those who don't know, motions are documents filed with the court that says that the prosecution has some evidence that should not come in, and here's why. And here's all the law and the cases having to do with that issue. Oh, and by the way, we have some evidence that should come in. Here's the case law and statutes which explain why it should be allowed in. Julie, with her exceptional writing skills, has developed our motion bank. We have probably over 100 motions that have to do with every major evidentiary issue that comes up in a case of this nature. Over half of all marriages today end in divorce. Years ago, mothers automatically retained custody of the children, and the father got visitation. This was due to what was called the tender years presumption. About 20 years ago, the laws were changed to make it easier for a father to obtain custody. Although at first blush this looked like a progressive change in the law, it has caused many problems. What has occurred is an increased competition between parents to gain custody, because now either parent has a right and a chance at the custody. This competition has become extremely bitter and often results in creating false accusations of physical or sexual abuse. This phenomenon has been examined and researched and now has been given the name Parental Alienation Syndrome. The Parental Alienation Syndrome is found when one parent constantly denigrates the other and works to brainwash the child against the denigrated parent. The Parental Alienation Syndrome is properly described when this campaign of denigration by one parent against the other takes root in the child, and the child then denigrates the other parent with criticisms that are either unjustified or exaggerated. In this way, a polarization takes place, and it appears that the child has one loved parent and one hated parent. Laymen can very easily see the manifestations of parental alienation. The child always sides with one parent against the other. What is not so easy to see is the mechanism by which one parent, the loved parent, can alienate or turn the child against the other parent or the hated parent. Years ago, Professor Richard Gardner of Columbia University described 4 causes of parental alienation. First, brainwashing by the loved parent. Secondly, subconscious and unconscious programming by the loved parent. Third, contributions which come wholly from within the child. And fourth, what he called situational factors. It would take an hour to describe in detail what is involved in each of these 4 areas. But here is a shorthand description. Brainwashing is the mechanism known by most laymen. Brainwashing is the conscious programming of the child by the loved parent against the hated parent. This is done by a campaign of denigration against the hated parent, by calling him an abandoner, an adulterer, an irresponsible homebreaker, and so on and so forth. The actual underlying reasons for the divorce are never really talked about with the child. The child is informed that the hated parent does not love the child, never spent money on the child, is an alcoholic, is violent, and uses drugs. In brainwashing, the loved parent is fully aware that they are attempting to turn the child against the hated parent. Another mechanism is described as unconscious factors. Often, unconscious factors are more effective than brainwashing. The loved parent, or the parent that is causing the alienation, can profess total innocence about what they are doing, because they in fact do not realize the damage they are causing. There are thousands of unconscious factors that can turn a child against one of its parents. These would include such things as speaking in a frightened voice when talking with the ex-spouse, frivolous reasons for missing visitation, such as a headache, or purposefully scheduling events during the ex-spouse's visitation time, adultifying the child by giving them the decision of whether or not to have visits and then supporting them when they do not want the visit, making the child feel guilty about time spent with the ex-spouse by telling them how much they will be missed when they are gone, by having continuous arguments with the ex-spouse in front of the child concerning visitation or money, and that old one about physically examining the child after visits with the father. Another major alienation factor is moving away from the hated parent to find better employment, when the true underlying reason for the move is to destroy the amount of time that the ex-spouse can spend with the child. A long campaign of subconscious programming is more effective than overt brainwashing, as it destroys the bond between the ex-spouse and the child. Another factor that influences a child to make denigrating comments and false accusations is one that is not normally recognized. This involves factors within the child that are independent of the parents. This child who has a basic psychological bond with one parent that is stronger than with the hated parent may go to great lengths to maintain that bond between the loved parent and the child. Remember, the child feels that they were once abandoned by the hated parent. When the divorce occurred, the child does not want to be abandoned a second time by taking sides against the loved parent, and will do anything to maintain that bond with the loved parent. One of the ways this is done is by making complaints against the hated parent. The child then gathers support from the loved parent. Often we find that the child is fearful of expressing love for the hated parent for fear that it will displease the loved parent, even though in actuality they do love the parent. This process can cause complaints that can start out as minor, but when a child custody battle becomes ferocious, small complaints can escalate into accusations of child abuse. Situational factors are another mechanism of parental alienation. In difficult custody circumstances, we often see a false accusation made at one of 2 moments. One of the moments is just prior to the hearing on child custody. Another is just prior to the wedding of the ex-spouse to another woman or man. These events can challenge the status quo of the child and precipitate a false allegation. You would be amazed at the gullibility of people who believe that a father for 12 years with no prior molest allegations would molest his daughter a week before a child custody hearing. In order to understand parental alienation, one must understand the motivation of the alienating parent. It is not love for the child, but revenge against the ex-spouse that motivates alienators in these circumstances. If the alienating parent really loved their children, they would realize that having a healthy relationship with both parents is what's in the best interest of the child. Instead, they continue the war with the ex-spouse through the child. The obsessive love for the child is a cover for the feelings of hatred towards the ex-spouse. We use the parental alienation process and the research that supports this description to show that there is another explanation for the accusations that have been made. I'd like to talk a little bit about the philosophy of our group. In cases such as these, the prosecution has a 98.5% win rate throughout the country. The defense wins at about 1.5%. Now, that's not our win rate. We have a 40 to 60 times higher win rate. Why is that? Well, a public defender handles 350 cases a year. Now, with 220 workdays in a year, you can imagine how much time they spend on an individual case. Now, serious felonies get less than an hour of time from the public defender because of this incredible workload. Now, for private attorneys, they typically handle 80 to 120 cases a year. Why? Because they're trying to pay for those yellow page ads. They take a lot of cases in and they plead as many of them as possible. They get a retainer and then they bargain with you and with the prosecution as quickly as possible so they can move on to their next retainer. You cannot evaluate a case until it is prepared for trial. Let me give you an example. I had a case of a grandfather who was charged with a molestation, and the prosecution thought he was guilty. Our investigator had met a Catholic priest, and he believed that the priest had information about the case, but the priest wasn't talking. Our investigator kept going back over and over and over again. On the fourth day of trial, the priest finally broke and turned over letters that had been written by our client's granddaughter. And in those letters, she said that she had sex with over 40 men in the congregation. Previously, she had been saying that she was a virgin and that the only person that she had been involved with was her grandfather. She was caught lying and making up stories. The charges were dropped on the fourth day of trial. This is the kind of tenacity that we bring to continuing litigation. We believe that the preparation must be completed before any decisions can be made about the case. We handle only 8 to 12 cases a year, and perhaps a couple of small cases that we have a special interest in. Our preparation begins on day one. We scan in all the documents, we index all the documents, we capture all audio tapes, we capture all videotapes, and they are put on our computers electronically. We prepare transcripts of all of these tapes. We prepare clips for presentation during trial and during the closing. We have a jobs list where we make a list of everything that we are going to do and the job assignments for every other member of the team that is going to work on the case. We have a chronology that we develop, which we primarily get from you, and we update consistently, telling us absolutely everything that happened in chronological order. We make a witness list while we are receiving these documents so that we can contact every person that is mentioned in any report that may be of any value to us. The reason for this? You can be reading on page 65 and it mentions a janitor who is not involved in the case. And on page 650, you can read about the janitor and now he's become a key witness. How do you go back and find that address that was on page 65? You can't. So we keep track of all addresses as we see them, as we run across them, along with phone numbers and other contact information. We make an outline of every witness's testimony. We do not wait to a week before trial. We begin the very first reading of the case making these outlines. All of these documents, a jobs list, a chronology, a witness list, and outlines for witnesses, are all prepared at the same time. We call it multitasking. It's extensive preparation that wins cases. Now, we can teach you everything that we're going to do on your case so that you are an equal partner in the preparation of your case. And we insist that you remain so. Remember, it's your case. Now, the prosecuting attorney will make offers whether or not you want them to. Our job is to make sure that you make an educated and informed decision on whether to accept any of these offers or whether to go to trial. Remember, there is hope. Now that you know the politics and seriousness of the offense that you are accused of, we would like to meet with you. We will try to stop the charges from being filed, if they have not already been filed, by contacting the police and the district attorney. Maybe, if they are presented another side of the case, they won't even file. We will protect the evidence for your defense. This must be done immediately. Before you meet with us, it would be important that you prepare a chronology of events and set out everything that has happened and the time order in which it happened. Clearly mark that attorney-client privilege at the top of the document so that if it is intercepted in any way, it is protected. We also need to know about your background and any prior allegations that have been made against you. You can survive these charges. We believe that the survival is based upon preparation, preparation, preparation. Defending against allegations of this type can be costly. However, you only get one trial. You only get one chance. We cannot guarantee the outcome. Those attorneys who do that are lying to you. What we can do is make sure that everything that can be done will be done. In this way, we maximize your chances of the best outcome in your case. We're known for being a big case firm. We don't go to court with 10 files under our arms, as you will see with many other attorneys. We only take cases where the stakes are very high. We take cases that require extensive preparation. There is a large learning curve for you to go through to get prepared for our meeting. We want you to watch this video before we meet and discuss your case. The meeting will be more meaningful if you do this. Now, I would like to introduce you to the team members. I'm Patrick Clancy. I've been practicing law since 1974. I'm what is called a certified criminal law specialist. In the state of California, an attorney is not allowed to call himself a specialist unless you're certified by the California State Bar. Basically, what that means is I did so many trials, so many appeals, so many writs, obtained recommendations from judges, recommendations from district attorneys, and that then gives you the honor of taking a second bar exam, much harder than the first. The first bar exam had 14 subject matters. The criminal law specialist exam has 1 subject matter. My involvement in P.A.S.C.R.A.A, a psychologist and a lawyer, it eventually evolved that we started practicing law together. He's known nationally because of the work that he's published. He published cross-examining experts in the behavioral sciences. And he also published bench book in the behavioral sciences, psychiatry, psychology, and social work. What these 2 books do is train lawyers how to cross-examine experts. It also trains judges. That's what bench book means. In what you look for in terms of scientific reliability with so-called experts who are testifying in the behavioral sciences. Cases of false allegations of child abuse and child molestation predates the McMartin case, the infamous case in Los Angeles. Our law firm, as far as I am aware, is the only firm that deals exclusively with issues of false allegations in abuse cases. Dr. Larandos is a major member of our team. He's a psychologist and an expert witness. I met him decades ago on the East Coast when we were both attending training seminars together and giving them together. Over the years, it developed to where he was testifying in my cases as an expert witness. But since he is an expert, Dr. Larandos heads up the science department of our team. He's been fighting junk science's use by the prosecution in abuse cases for decades. His knowledge and research are invaluable to our team and will be invaluable to you. The next person is our investigator. He is probably one of the central figures in our team because I believe the cases are won or lost based upon investigation. Harvey Shapiro was a member of the Riverside Sheriff's Department and was the head of their Crimes Against Persons Unit, which is charged with investigating child molestation cases.